Forming the corporation. As an individual doing business without a corporation or business organization, you're personally liable for all the debts of the business. This means your home and all your personal assets are on the line if the business fails, as many of them do. It also means that you're almost sure to be unable to raise funds from outside investors, as they want to buy shares in a business entity, not lend money to an individual. Forming a corporation is one of the first steps in the startup process. A corporation is a legal entity, or an imaginary person, which has a legal personality distinct from those of its shareholders. A corporation isn't very tangible at all. It's essentially a nexus of contracts. The first contract is with the state. Incorporation means that so long as certain conditions are met, the state grants limited liability to the shareholders of the corporation. So if the corporation fails, the shareholders lose their investment and shareholding, but their other assets are protected. As a separate entity, the corporation has the right to sue and be sued, to have assets, to employ agents, such as managers, to engage in contracts, and to make bylaws governing its internal affairs. If you conceive the idea for your startup when working for another company, if you're not careful, the idea could belong to your employer, not to yourself. Before doing anything about your idea, you may want to consult with a lawyer specializing in intellectual property and startup companies. A good attorney will advise you how to separate your intellectual property from that of your employer. If your idea and your new venture is clearly separated from your day job, in certain US states such as California, your employer may be unable to claim rights to your invention, and you may be able to keep it for yourself, then transfer ownership to your startup company. You need to be very careful here, as using your employer's laptop computer, email system, telephone, or any other resources could invalidate your claim that the new idea was not conceived within the scope of your job, and your claim that it belongs to yourself, not your employer. So hiring a lawyer may be the very first step of your startup journey. The founder of a startup often starts the business before forming the corporation. In legal terms, the founder is known as a promoter. It's important to understand that the promoter is personally liable for all the duties and liabilities incurred before the corporation was formed. So if you go and engage with suppliers and service providers on behalf of your new startup company, you're personally liable for all the debts incurred before the papers of incorporation are filed with the state. After the incorporation takes place and the corporation legally exists, it doesn't automatically inherit the liabilities that you, as the promoter, incurred on the company's behalf. Even if the corporation adopts the contracts from you, it doesn't relieve you of promoter's liability. To pass the liabilities onto the corporation, you may have to enter contracts saying that the corporation will adopt the responsibilities from you, plus additional contracts with the suppliers and service providers that's saying that they will release you of liability and they will look exclusively to the corporation for payment. To avoid promoter's liability, form the corporation early in the startup process and take care when making commitments that contracts are formed with the company and not with yourself. Corporations are not the only form of business organization. A sole proprietor is essentially an individual doing business as himself or herself, often under a business name approved by the city or state. Creditors of a sole proprietor look to the individual for payment of debts, as the business and the individual are legally one and the same. A general partnership is two or more individuals doing business together. It's a separate entity in many ways, but similar to a sole proprietorship in that the partners are liable for the debts of the business. Liability can be restricted for some partners in a limited partnership. General partners are held liable, but a limited partner can invest in this type of business without incurring business liability beyond the money they actually invest. You may be wondering why anyone would want to do business as a sole proprietor, general partnership, or limited liability, and the answer often lies with taxation. A corporation is a taxpayer. Sole proprietorships and partnerships are not. It's an oversimplification, but profits made by a corporation can be taxed twice. Firstly, in the corporation's tax returns, and secondly, in the tax returns of the corporation's shareholders after the profits have been distributed as dividends. The profits generated by these sole proprietor and partnership businesses pass through to the owner, and they are not taxed at the entity level. Until recently, business owners had the choice between limited liability offered through a corporate structure and the tax efficiency of the partnership. Then, an interesting hybrid was created. The LLC offers the best of both worlds, limited liability and pass-through taxation. The LLC is highly appealing, and you would think that the days of the corporation were numbered. LLCs have displaced corporations in Hollywood and other industries. But in Silicon Valley and the technology sector, this is not the case. Corporations still rule supreme. The reason for the continued dominance of corporations is that investors have grown to know and trust the huge body of corporate law. The law governing LLCs is relatively new and untested. There are alternatives, but if you want to raise funding from venture capital investors for a technology startup, forming a corporation remains the only viable option. The C Corporation is a regular corporation and provides limited liability for the owners. The corporation is taxed, and so are the shareholders. The company is able to issue various forms of shares and securities, including common stock, preferred stock, warrants, and options. There are no restrictions on the number of shareholders or type of shareholders within a C corporation, as it does not qualify for any preferential treatment in relation to tax. When it comes to IPO, merger or acquisition, investment, or any significant transaction, you can be sure that the most recognized and accepted form of business organization today is the C Corporation. Corporate acquirers, Wall Street investors, and investment banks are familiar with C Corporations. The C Corporation is what venture capital and other investors feel comfortable with in Silicon Valley and the technology sector. They've grown to know and understand the body of law that has grown around C Corporations, and most are unprepared to consider investing in any alternative form of company. An S corporation is a regular corporation that makes a valid election to be taxed under Subchapter S of Chapter 1 of the Internal Revenue Code in the United States. In general, S corporations don't pay any income taxes themselves. Instead, the corporation's income or losses are divided among and passed through to its shareholders. The shareholders must then report the income or loss on their own individual income tax returns. In order to make an election to be treated as an S corporation, the company must qualify as follows. It must be a corporation or a limited liability company. It can have no more than 100 shareholders. The shareholders must be U.S. citizens or U.S. residents. They must be people, not corporations or partnerships. However, certain tax-exempt corporations like 501c3 non-profit corporations are allowed as shareholders. They must have only one class of stock, so you can't issue preferred as well as common stock. Profits and losses must be allocated to shareholders proportionately to each one's interest in the business. If a corporation meets these requirements and wishes to be taxed under Subchapter S, its shareholders may file a form with the U.S. Internal Revenue Service and qualify for S corporation treatment. As corporate investors are not allowed, and an S corporation cannot issue multiple classes of stock, the S Corp is not suitable for startup companies that are looking for venture capital funding. However, an S corporation can always be converted back to a C corporation if necessary to raise funds from investors. A limited partnership is a form of partnership similar to a general partnership, except that in addition to one or more general partners, there are one or more limited partners. The general partners, in all major respects, are in the same legal position as partners in a conventional general partnership firm, i.e., they have management control, they share the right to use partnership property, they share in the profits of the firm in predefined proportions, and they have joint and several liability for the debts of the partnership. As in a general partnership, the general partners have actual authority as agents of the firm to bind all the partners in contracts with third parties that are in the ordinary course of the partnership's business. Like shareholders in a corporation, however, the limited partners have limited liability, i.e. they're only liable on debts incurred by the firm to the extent of their registered investment, and they have no management authority. The general partners pay the limited partners the equivalent of a dividend on their investment, the nature and extent of which is usually defined in the partnership agreement. Limited partnerships are distinct from limited liability partnerships, in which all partners have limited liability. Venture capital funds and investment organizations have traditionally been organized as limited partnerships. However, offering both limited liability and pass-through taxation, LLCs are now growing in popularity as the type of organization used by the investment community, and many limited partnerships are being replaced by LLCs. Limited liability companies, or LLCs, are a relatively new and increasingly popular form of business organization in the US today. This is because they offer both limited liability for the shareholders and the possibility of pass-through taxation. Well, the term shareholders is used broadly here, as the owners of an LLC are known as members, as they are not issued with shares, but with membership interests. There are no directors, but managers. The terminology is different, but the basic functions of the LLC are very similar to a corporation. LLCs can be very simple organizations with a single class of member and a single mode of management. They can also be extremely complex, with membership structures that resemble the multi-tiered stock structures found in large corporations. DreamWorks, for example, is an example of a large movie studio in Hollywood that was organized as an LLC. The owners wanted to combine an efficient tax structure with a liability shield and chose the LLC instead of a traditional corporation. The Hollywood acceptance of the LLC has not yet reached Silicon Valley, where venture capital investors still feel comfortable with the body of law governing corporations and refuse to invest in LLCs or any other form of business organization. When selecting which type of business organization is best for your startup, you need to consider several factors. If you're looking to raise funding from venture capital investors operating in the traditional Silicon Valley style, then there is only one realistic option today, the C Corporation. The C Corp will make life easier for you when entertaining other significant transactions, such as IPO or sale of the company. However, if your exit is an asset sale, the C Corp could expose the shareholders to double taxation. The proceeds of the asset sale are taxed at the corporate level, then taxed again by shareholders receiving dividends. an S-Corp or LLC may help you avoid this type of double taxation, but smart lawyers can often structure C-Corps and transactions in tax-efficient ways that virtually eliminate the difference in tax liability. The C-Corp can be structured as a tax-efficient entity. Professional advice is always recommended. Your lawyers and accountants will help you choose what's best. Make sure they consider the long-term issues, as some advisors are prone to look merely at tax efficiency today without considering the factors that will best facilitate an IPO or sale of the company tomorrow. Although the vast majority of publicly traded companies and almost all venture-backed startups are Delaware C corporations, an LLC or S-Corp may be better for you. It all depends on who you are and what you're trying to achieve. The vast majority of corporations formed in the US today are incorporated in the state of Delaware. Delaware is very hospitable to corporations and make incorporation relatively quick and easy. Technology investors are accustomed to investing in Delaware corporations. They're familiar with the body of law that's grown around Delaware corporations in the last century, and many refuse to invest in corporations formed anywhere else. Don't worry, you don't have to visit Delaware to form your corporation there. Everything can be done online and within minutes. You will need to register to do business in your state of residence, and you will need an agent for service of process in Delaware, but these are not difficult to arrange. If you want to avoid promoter's liability, personal liability for the debts incurred before the company was officially formed, then it's a good idea to incorporate as soon as you possibly can. Transferring promoter's liability to the corporation after it's formed is possible, but it requires several contracts. You can form your corporation online today. All you need is a credit card and an internet connection. However, incorporating through a lawyer is often preferred, as the lawyer will be able to establish the state and local licenses you need to do business and structure the articles of association and bylaws that govern how the company operates. Of course, forming a corporation involves paperwork. One of the first papers you'll need is a certificate of incorporation from the state. This essentially proves that the corporation exists and is recognized by the state. If you're incorporating in Delaware, this certificate will be issued by the Delaware Secretary of State. If you're doing business in California or a state other than Delaware, then you need a second certificate of qualification from your state of residence. This recognizes that you're incorporated elsewhere, but you're approved to do business in your home state. Of course, then you need to prepare the Articles of Association, sometimes called the Charter, and the corporation's bylaws. Here you can define the scope of the business, how directors are elected, when board meetings are to be held, and other significant issues dealing with the governance of the company. The Articles of Association are rigid, difficult to change, and somewhat set in stone once the corporation is formed. The bylaws, on the other hand, are more easily altered by the board of directors and the shareholders. It's good practice to diligently record minutes of board meetings and keep them on file. When you come to issuing shares, you step into the jurisdiction of the SEC, the Securities and Exchange Commission, and the myriad of rules governing the sale of securities. Forms need to be filed with the SEC, and strict procedures followed when issuing stocks, bonds, or other forms of securities. This is a specialist area, and good legal advice here is essential if your paperwork is to be properly filed and kept up to date. When forming a startup company, it's important to understand where the power and authority lies within a corporate structure. The chain of authority essentially looks like this. Management is directed by the CEO. The CEO is appointed by and reports to the board of directors. Depending on the corporation's bylaws, the other officers such as the CFO, General Counsel, could be appointed by the CEO or by the Board of Directors. The Board of Directors may only convene for a few hours a quarter, but in the eyes of the law, this group of individuals, acting as a board, is charged with the authority to manage the company. The board can hire and fire the CEO and officers. Interestingly, no individual member of the Board of Directors has any power acting alone. The power rests with the board acting as a whole. The Board of Directors is appointed by the shareholders. In venture-backed companies, rights of common shareholders, such as the founders and employees, to elect directors are usually limited. The preferred shareholders, i.e. investors, have rights to elect certain directors, and the preferences attached to their stock often provide these investors with control of the Board of Directors. When the Board of Directors is all-powerful and loaded with responsibility, the Board of Advisors has no power and acts merely to provide advice. This is not to say that a position on the advisory board is not alluring. For many individuals, a position on the Board of Advisors is very much more appealing than one on the Board of Directors, as the advisors are not held responsible if the company fails, breaks the law, or somehow upsets the SEC. The laws governing a U.S. corporation, like all U.S. laws, derive ultimately from the U.S. Federal Constitution. There are few sections of the Constitution that deal with technology startups, but the rules promulgated by the SEC and other federal agencies under the Constitution are highly relevant for many small corporations with outside investors. The corporation is a creature of the state and is governed by state statutes and case laws. The corporate charter, also called the Articles of Association, are filed with the state and essentially act as a constitution for the company itself. The bylaws are extensions of the charter that are generally more easily amended by the shareholders and the Board of Directors. The corporation's bylaws and charter control the operation of the company to the extent that they do not conflict with state law, and state law controls to the extent that it does not conflict with the U.S. Constitution and powers of the federal government to control interstate commerce. You'll notice from this chart that the founders of the company have limited powers. As holders of common stock, the founders' powers are restricted to electing directors. When preferred stock is issued, the power is diluted to elect only one or a small number of directors. Conflicts can be avoided when the stakeholders in the corporation understand where the power and authority lies. For a better understanding of how this applies to a startup company in the technology sector, you may want to look into the preferences written into preferred stock agreements with corporate investors, like veto rights and other terms that can affect how significant decisions are made within the company. The general rule is that shareholders of a corporation or an LLC are not held personally liable for the company's debts and liabilities. But there are exceptions to this rule, and the implications can be significant for startup entrepreneurs. If the corporation and the individual are essentially one and the same, the courts will often ignore the corporate liability shield and hold the individual responsible for debts incurred by the company. The debt may be held by the company, but the creditor is able to reach through to the shareholder, taking his or her own personal assets in payment. This piercing of the corporate veil usually takes place when there's only one or very few shareholders, assets of the company and the individual shareholder have been commingled, and the corporation is thinly capitalized, relatively little money invested by the shareholders, and corporate formalities such as board meetings and minutes have been disregarded. The law relating to LLCs is not as well established as that of corporations, but early indications are that piercing the veil of an LLC may be more difficult than that of a corporation. The LLC may become a better liability shield than a corporation, but so far there's little in the way of case law to bet the farm on this. The liability shield provided to investors in corporations and LLCs was intended to encourage outside investment in companies with numerous shareholders. The shield can be pierced by courts when the company and the individual is one and the same. Where there's a single shareholder and where the court sees the company is nothing more than a sham, it will often hold the individual personally responsible for the debts of the company. As you'd expect, there are ongoing costs associated with operating a corporation. If your company was incorporated in another state, such as Delaware, you'll need to retain a local agent for service of process, essentially an agent in the state that will receive any writs or legal complaints on the corporation's behalf. There's an annual fee for this service. There are also state franchise fees that are calculated based on the size of the company. These taxes levied by the state of incorporation usually depend on the size of the company. Small companies, calculated on either the number of shares or the paid-in capital, pay less than large corporations. For Delaware corporations, these fees can now be calculated and paid annually online. Your home state may also charge annual fees for the ongoing right to do business there. Then there are the accounting and legal fees you'd expect from operating a business. When allocating the budget for running a corporation, you can estimate the cost will be similar to that of running a car. At the minimum, the corporation will cost you several $1,000s a year.